Hot Business on Hot 1027 is powered by Standard Bank Business and Commercial Banking, your partner with sector expertise and tailored solutions to help you grow with purpose and ambition. Standard Bank is an authorized FSP and registered credit provider.
Now, the sudden dissolution of the South African Tourism Board is raising sharp questions about governance, continuity, and I also would throw into that mix ministerial overreach. The Institute of Directors in South Africa says board should never be left unable to act simply because a chairperson steps down, and that King 4 clearly sets out mechanisms to ensure stability. But with the big tourism Indaba just weeks away, the collapse is triggering wider concerns about how public entities are being run and whether due process is being followed. In that respect, I am joined by the Chief Executive of the Institute, Professor Parmi Natesan. Parmi, from a governance perspective, and welcome to you, what's your biggest concern about how this dissolution was handled?
Thanks, Jeremy. Yeah, I guess the crux of this matter is really that we're told that the chairperson of the SA Tourism Board stepped down a few weeks before this meeting of contention happened. And look, the Tourism Act is clear. It says the minister appoints the board, and the minister also, by the way, appoints the chair and deputy directly, unlike other boards where shareholders appoint a board and the board themselves choose their chair. So what this really means is there was a casual vacancy on the board at the time. The Act also says that the minister appoints people to fill a vacancy, but it gives no time frame, nor does it give any transitional arrangements. So the minister could take as long as they want to appoint a new chair. And in the meantime, how does the board function? It does not seem that there's any requirement for the minister to then nominate someone as acting chair in the meantime for the board to be able to do their job. Funny enough, the exact same act in section 26 refers to the board being able to nominate someone as an acting CEO if a casual vacancy arises for the position of CEO. So similarly for the role of chair, which is also a very key governance role, why not have a similar provision so that the board can continue functioning? I just feel this board was between a rock and a hard place. Imagine you're functioning as a board, you're in office, you have the fiduciary duties to act in the best interest of this organization. Information comes to your attention about the CEO, serious information. You have an obligation to hold the CEO to account. And now you're sitting with, do we call a meeting or do we not? If you didn't call the meeting, then I would argue that someone else would come from another angle of the law and say you were negligent and didn't fulfill your duty as a board member at that time. Now they call the meeting and then are told, well, they weren't allowed to because the Act says the chairperson may convene a special board meeting. Now, I feel this is form over substance. The Act may say the chairperson may convene, but I don't think the Act ever intended or envisaged that there wouldn't be a chairperson for a period of time.
So how does this fit into the King 4 principles?
Well, King 4 talks clearly about, firstly, succession planning is one thing, so that, when a key role player like a chairperson steps down, there shouldn't be this vacuum when no one knows who's going to fill the position. There should actually be someone already identified as having, been put in place to step in for the position of chair when a vacancy arises. That's on the one hand. On the other hand, King 4 also talks about a lead independent director. And one of the duties of a lead independent director is to act when the chair is not available or not there. In this instance, and I know many public sector entities don't have a lead independent director, but then let's say a deputy chair. The board charter of the organization could easily stipulate that if the chairperson is not available, the deputy chair steps in as chairperson, acting for a period of time so that the board can function.
What do you think the consequences are for the operational capacity of the entity itself as a result of this decision?
So there's a couple of things. Firstly, the board meeting question, we are told the decision was taken there to suspend the CEO. Operationally, there are concerns as to whether the company will continue operating effectively, etc. The one other interesting clause I saw in the Tourism Act when I read it again this morning in Section 18, subsection 9, it says very specifically, no decision taken by or act performed on the authority of the board shall be invalid merely because of a casual vacancy on the board. Now, our lawyer friends can weigh in there, but on my non-legal interpretation of that, I feel the suspension of the CEO stands, regardless of whether there was a chair in place or not.
The board or the board that's been hoofed out now, as far as you understand, does it have any recourse at all?
I think that's a difficult question because, in a governance structure, it is ultimately up to the shareholders who the board members are. The shareholders have authority to appoint directors and to remove directors. There's one clause in the Tourism Act. It says the minister may dissolve the board, but it also says on good cause shown. And I guess that's where our contention is going to be now. I've already seen political parties indicating that they want the minister to account to Parliament on this very fact of, whether there was good cause here to remove the board. And I guess that's where it's going to play out now.
Typically, how would you demonstrate good cause, though? I suppose there are a raft of different ways in which you would apply that.
Correct, and it's probably very subjective. Your good cause may be different to my good cause, I guess. Ultimately it's going to be now Parliament holding the minister to account, and let's see if she can convince them that this was the right decision for good reason.
And Parmi, it's also about optics, because it's worrying that this governance crisis comes just a month before one of the country's biggest tourism conferences, and that particular sector is vital to the growth of this country. It also comes ahead of the G20.
Yes, I agree. And the optics also of constant instability or perceived instability of an organization, because I went back in the history and I saw in 2023 the whole board was dissolved. In 2024, February of 2024, a new board was appointed. Then in September of that same year, the chair and deputy were removed and a new chair was appointed. That's the chair that now stepped down in July. So that chair didn't even serve for a year. And now we're in August 2025 and the whole board is dissolved again. So you're going to have a whole brand new set of individuals coming on to serve who have no institutional knowledge to take this organization forward. And yes, they're going to take some time to settle in. And yes, the induction programs, etc., can be put in place. But I also think there's something to be said for a board having a decent run of tenure in order to settle in and fully understand an organization.
Now, look, we don't know how this is all going to end up, but looking forward, are there specific lessons that other state-owned entities should take from this episode to avoid similar governance breakdowns, which we have seen in the past, have we not?
Absolutely. And I think, look, there's a couple of concerns in terms of how appointments are made. So the one I mentioned earlier is generally shareholders appoint a board and the board then chooses their chairperson and deputy chairperson. So that's one of the things that's a little bit clashing in this public sector legislation. The other is also, oftentimes in the public sector, the minister also appoints the CEO in addition to appointing the board. And therefore, you often see CEOs wield a lot of power. And if they're not happy with a board's decision, they can influence a minister to remove a board. So I think that's the other thing. I think key ultimately is there needs to be substance over form. We can't be applying the letter of the law strictly to find these holes to tie people in. We need to be thinking about the intention of the board and the intention of the way the legislation was written. Clearly, there's an intention that the board should be allowed to call a special meeting if it's warranted. And therefore, why pick on the fact that, there wasn't a chairperson at the time when this meeting was called?
And that's where we are going to leave it. Just to add a note to that, I've just got a statement from the Tourism Business Council of South Africa. It says it notes with disappointment the decision to dissolve the board of South African Tourism. I'm going to thank Professor Parmi Natesan, who is the Chief Executive Officer of the Institute of Directors.
Our Business is powered by Standard Bank Business and Commercial Banking, delivering expert support and tailored solutions to help your business grow with confidence, clarity, and resilience.